Contracts are everywhere. We encounter them daily, often without even realizing it. Buying a cup of coffee, streaming a movie, or even accepting a job offer all involve contracts. Understanding the basics of contract law is essential for navigating our personal and professional lives. It empowers us to protect our rights, fulfill our obligations, and avoid costly disputes. This essay will break down the fundamental elements of contract law. We will explore how contracts are formed, the different types of contracts, and what happens when a contract is broken. By understanding these basics, you'll be better equipped to handle contractual relationships with confidence. At its core, a contract is a legally binding agreement between two or more parties. For a contract to be valid, it must contain three key elements: offer, acceptance, and consideration. An offer is a clear proposal by one party to enter into a contract with another party. It must outline the specific terms of the agreement. For example, an offer to sell a car would include the price, condition of the car, and payment terms. Acceptance occurs when the other party agrees to the terms of the offer. This acceptance must be clear and unambiguous. A simple yes or a signature on a written contract can signify acceptance. Consideration is the exchange of something of value by each party. This could be money, goods, services, or even a promise to do something. Consideration ensures that both parties are getting something in return for their agreement. Beyond offer, acceptance, and consideration, two other elements are crucial for a contract to be legally enforceable: capacity and legality. Capacity refers to the legal ability of the parties to enter into a contract. Minors, individuals under the influence of drugs or alcohol, and those deemed mentally incompetent may lack the capacity to contract. Contracts entered into by parties lacking capacity are generally voidable. Legality means that the subject matter of the contract must be legal. Contracts for illegal activities such as drug trafficking or gambling in prohibited areas are unenforceable. Section 4. Diverse forms of contracts, from written to implied agreements. Contracts can take many forms. They can be written or oral, bilateral or unilateral, express or implied. Written contracts are agreements that are documented in writing and signed by the parties. These contracts provide clear evidence of the terms agreed upon and are generally easier to enforce. Oral contracts, on the other hand, are agreements made verbally. While enforceable, proving the terms of an oral contract can be challenging. Bilateral contracts involve promises made by both parties. For instance, in a contract for the sale of goods, the seller promises to deliver the goods and the buyer promises to pay the agreed-upon price. Unilateral contracts involve a promise made by one party in exchange for an action performed by the other party. A reward poster for a lost pet is an example of a unilateral contract. Express contracts are those where the terms are explicitly stated, either orally or in writing. Implied contracts, however, are formed by the conduct of the parties, even if the terms are not explicitly stated. Section 5. Breach of contract when promises fall apart. A breach of contract occurs when one party fails to fulfill its obligations under the contract without a legal excuse. This breach can be material, meaning it strikes at the heart of the agreement, or minor, involving a less significant term. For example, if a contractor fails to complete a construction project on time and according to the agreed-upon specifications, this would likely be considered a material breach. However, if the contractor uses a slightly different brand of paint than specified in the contract, but the overall quality of the work is not affected, this might be considered a minor breach. Section 6. Remedies for breach seeking justice and compensation. When a breach of contract occurs, the non-breaching party has several legal remedies available to seek compensation or other forms of relief. Damages are a common remedy for breach of contract. They aim to compensate the non-breaching party for the financial losses suffered as a result of the breach. Specific performance is a remedy that compels the breaching party to fulfill its contractual obligations. This remedy is typically granted only when monetary damages are inadequate, such as in contracts involving unique or irreplaceable goods. Rescission is a remedy that cancels the contract and returns the parties to the positions they were in before entering into the agreement. This remedy may be granted in cases of fraud, misrepresentation, or other situations where it would be unfair to enforce the contract. Understanding the basics of contract law is crucial for protecting our interests and navigating the complexities of agreements in various aspects of our lives. By grasping the fundamental elements of contract formation, types and breach remedies, we can confidently engage in contractual relationships and ensure that our rights and obligations are upheld.